Hello, I'm Jess Karayan-Keeney. I'm an attorney licensed to practice law in the state of California. I practice family law. I'm the Department of Child Support Services attorney for two very small Northern California counties. I'm also the city attorney for a very small Northern California city. I've started doing these instructional videos to educate people regarding filling out their legal documents. My primary focus so far has been documents relating to the Department of Child Support Services. Today, I'm going to go over what happens when you get a letter from the Department of Child Support Services. You might see my kitty Carmen during these videos, or my son. Anyway, I'm going to go over what happens when you get a letter from the Department of Child Support Services with a motion and a court date. And I'm going to go over how to fill out a response to that motion you get from the Department of Child Support Services. Now, for my warning, this is not legal advice. This is for educational purposes only. And by watching this, you're agreeing this is not legal advice. This is for educational purposes only. You're more than welcome to ask me questions in the comments below, and I'll do what I can to answer those questions in a later video. It won't be legal advice. It will simply be how I've seen that situation handled or how I have handled the situation. You'll need to find an attorney who can analyze your situation and figure out what solutions are best for you. So happy watching. Grab yourself a pen. And what I would like everyone to realize is that when they get this packet in the mail from the Department of Child Support Services, they can hang on to it, they can grab a pen, they can immediately sit down at their dining room table and fill out a response. It can be really scary, and people have a tendency not to want to talk to the Department of Child Support Services, but painful things often happen when you go that route. Here we are. We've opened up a piece of mail from the Department of Child Support Services. This is what your mail might look like. It might not look exactly like this, but this will give you an idea what you need to do. And throughout this video, you may hear my toddler talking or playing. Sorry, I can't do a whole lot to change that. Anyway, I've redacted a bunch of information in this letter. Up here would be your name and address. It would be your CSE case number. That's a really long case number that the department uses to find your case in their system. The custodial party's name. The custodial party isn't always the party that has the most custody of the kids. Usually it is, but in our system, it's the party that receives child support. The non-custodial parent is the parent who pays the child support. Usually it's the parent that has less parenting time, but not always. And then here is the court case number. We can also look your case up with your court case number, custodial party's name, non-custodial party's name. Can get a little bit tough to look up cases when custodial and non-custodial party have common names. So that's why I like the CSE number. That's why I like the court case number. If you call the Department of Child Support Services and they ask for your social security number or your date of birth, it's probably to make it easier to find your case. So I'll just go through this letter real quick. This is a letter that was sent to a non-custodial party. I'm not the best at reading out loud either, so forgive me. Participant responsibility to file documents with the court and protect confidential information. Dear non-custodial party, we, as in the Department of Child Support Services, may forward documents to court for you. While it's your responsibility to file documents related to your case directly with the court, it is the policy of the Department of Child Support Service, Child Support. You may hear me call Department of Child Support Services DCSS as well, to forward appropriate legal forms and supporting documents received from participants such as yourself to the Superior Court for filing. Documents you return to child support for the purpose of modifying your order may also be forwarded to the court. Documents intended for the court but received by child support will be routed to the court as a convenience to you. Documents forwarded to the court from child support may also be served on the other party in the court case. We cannot change information on paperwork we send to the court. Documents filed with the court may become a matter of public record. Child support will not remove or change any information on forms that are submitted for filing with the court. So please be aware that private information such as your address or social security number on documents sent to the court by child support can become public record that anyone may see. I'm going to stop right here and I'm going to say make sure that you redact social security numbers for anything that's being filed with the court. If there's a domestic violence issue in your case, then talk to an attorney about redacting your address. What I like to see parties do when there's a domestic violence issue is go get a P.O. box. That way the other party can still have an address to send court documents to, but the other party doesn't necessarily know where the protected party lives. Secretary of State may be able to give you a safe at home address as well. So that's an aside. We are not your attorney. Since current laws, I'm back to reading the letter, by the way. We are not your attorney. Since current law does not allow any child support agency to provide legal representation to you, you or your attorney are responsible for properly completing all forms prior to filing them with the court or submitting them to child support. Incomplete or improper forms may not be accepted by the court. The routing of completed documents from child support to the court as a courtesy to you does not create an attorney-client relationship between you and child support. Hang tight, baby. I'm making a video so that people know about these letters they get from the Department of Child Support Services. Back to the letter. Legal help is available. If you have any questions or concerns about private information on legal forms and documents, we strongly encourage you to seek legal assistance or talk to your county's family law facilitator office for possible options. If you have any questions, please visit Customer Connect at, and then it gives the contact information. At some point, I will have a copy of this letter and all the attachments scanned and uploaded to my website. And when I finally get that done, I'll put the link in the description. Don't go looking for it immediately because you're not going to see it immediately. Anyway, back to the letter. Then the letter ends. So even though a Department of Child Support Services may forward your documents to court for filing, I really, really want every participant to take responsibility for serving their forms on the Department of Child Support Services, on the other party, and filing those forms with the court. In another video, I went over how to serve and file forms. This is your case. It's your responsibility to make sure that you get everything properly served and filed. So we'll go on to the next page. By the way, the forms you get or the letter you get will probably be double-sided. These aren't because I printed them at home and my printer doesn't conveniently do double-sided. Trees are a renewable resource, but my time isn't, so I didn't make these double-sided. But again, you'll probably get double-sided forms. So now here's another letter from the department that you'll get. Same thing, case number, custodial party, non-custodial party, court case number, and then it's addressed to you. So dear, in this case, non-custodial parent, a court hearing for this case has been scheduled for your court case involving the child or children you have with the other parent above. The date, time, and place are shown below, and the paperwork is enclosed. So the date, and then I redacted the actual date because I didn't want anybody to be able to go on the court calendar and kind of try to figure out who these documents were related to. But your letter will have the entire court date, the time, the address of the courthouse, the department, and the room. And then there will be some boxes checked. So the options are: you must attend court,
You do not have to attend court. In this case, you do not have to attend court is checked. An agreement has been reached. That's not the case here, but sometimes it happens. Enclosed is additional information that has been received by this office that may affect the amount of the child support obligation. That one's not checked here. But in my offices, we do, hang on a sec. Okay, back to this. In my offices, we attach our supporting documents to our motion so that the parties can see what information we are relying on in making our request. So even though this box isn't checked, this box very well could be checked in my offices. Okay, this next one's checked. Enclosed are additional forms that must be completed and timely filed at least 9 court days before your hearing date, with the Superior Court at the address above and served on all parties. You may serve the local child support agency listed below by mailing a copy of the forms to the following address. And then it gives the address of your local child support agency that served these documents on you. And then if there's any other information, this box here, other, will be checked, and there will be other things written here. When I used to do these documents for my offices, I would usually put a little message there saying that if you don't agree with what's being requested, you should show up in court. Even if the forms don't say that, that's always the case. If you don't agree with what's being requested, show up in court. Even if you do agree with what's being requested, it is entirely possible that something else could come up in court that you need to be there for. And you need to file your response, because it's possible that if you don't file your response and you just show up in court, or you don't file your response and you don't show up in court, your side is going to be completely disregarded. I mean, we show what we're relying on in our motion. Not all counties do that. Fill out the response, show up in court. That's what I always advise my clients when I am representing one of the parents. Okay, and then we're back to the letter. In this package is our, and then there's a number of things that are in this package. I noticed that notice of motion isn't checked here. There is in fact a notice of motion in this packet. There's also an income and expense declaration for you to fill out, and then there's a response to the governmental notice of motion for you to fill out. The letter continues to read, this hearing may be continued or taken off calendar without further notice to you. A little quieter, please, baby. We will keep you informed of the progress of this case and will provide you with copies of any written court orders after they have been entered. If you cannot appear at the scheduled date or do not live in California and would like to schedule an appearance by telephone, please call us at, and then there's a phone number right away. Please read the important notice enclosed with this letter. Remember, children are not allowed in court unless you have been subpoenaed to bring them. So this is important as well. A lot of times children show up in court, and I specifically ask that they be excluded from the courtroom. And I know it can be a hardship because not everybody has child care, but it is inappropriate for children to be in court hearing their parents talk about child support related to them. And sometimes it's not a case related to those particular children, but it's still not appropriate for the kids to be in court unless they've been subpoenaed. So keep them out of court. If you have to bring them, bring a friend with you so your friend can sit out in the hallway with your kids while you're in court. Back to the letter. If you fail to appear at the hearing without making arrangements with this office, a child support order may be entered against you. And if you're the custodial parent, an order might be entered that you don't agree with. So it's important to show up at court. Other options, if you can't personally appear in court, there's the appear by phone option. And you can also hire an attorney, which is kind of expensive, to appear on your behalf. You've got to figure out what's best for your case. Back to the letter. If you have any questions, please visit Customer Connect at, and then there's a whole bunch of contacts. Sorry about that. That's my son. Whole bunch of contact information, and then it's signed by the person who sends the letter. On to the next page. Again, this one's blank. Here's the important notice. It may be important that you attend the hearing. The local child support agency does not represent you or your children. You may have important information about the other parent, such as information about his or her income or assets that will not be presented to the court unless you attend the hearing. You have the right to attend the hearing and to be heard in court and tell the court what you think the court should do with the child support order. This hearing could change your rights or your children's rights to support. No attorney-client relationship exists between this agency and you or your children. Because no attorney-client relationship exists, communications from you to the agency are not privileged. No representation or relationship will arise because this agency provides service that you have requested. This agency may provide support enforcement services to the other parent. And then down here are sections of the family code that apply to this notice. So if you want to go read more, you can go check out these sections of the family code. Another blank page. Now we get into the notice of motion. I'm going to break this series up into a bunch of different parts so that you don't have to sit through one really long, terribly boring video to get your answers. So in the next section, we're going to go over reviewing a notice of motion to see what's being asked for.